Thank you for coming to tonight's event. It's a special occasion because we're doing something a little different than what we've usually done as part of the McGill Arbitration Society. Tonight's event is on religious arbitration and the interaction between legal traditions outside of mainstream tradition. My name is Keita Chong. I'm the president of the McGill Arbitration Society. Tonight I have the pleasure of introducing our three panelists. In the middle is Natasha Bakht, and on her left is Rabbi Michael Whitman, and on her right is Professor Ahmed Ibrahim.
As you may know, Quebec's civil code does not permit the use of arbitration in family law matters, but that's actually not the case in Ontario or indeed in any other province. So, when a group of Muslims in Toronto announced that they would use the choice of law provision, as it's known, in Ontario's Arbitration Act to use Sharia law to help resolve family law matters, a rather large controversy erupted. And the uproar was, in fact, unprecedented, and it included an onslaught of fear-mongering newspaper articles, op-eds, television commentaries, that confirmed the view that Islamic fundamentalism was an imminent threat in Canada. Protests were led worldwide against Sharia courts in Canada. The fact that the debates were, in my view, characterized by irrationality was demonstrated by the fact that the Quebec MNA, Fatma Houda Pepin, led a unanimous motion opposing Islamic tribunals in Quebec, in the Quebec National Assembly, even though, as I mentioned, the province's civil code specifies that actually arbitration cannot be used to resolve family law disputes. So what we'd like to do today is explore the use of religion, specifically Judaism and Islam, in family law matters and consider what the relationship should or ought to be between religion and civil systems of law. In Quebec, even though there's no family arbitration that is permissible, you can mediate family law issues religiously or otherwise, or couples can negotiate a domestic contract of their family law issues, which can, of course, include religious matters. So during the religious arbitration controversy in Ontario, there was much public debate about why people would want to use religious arbitration to resolve their family law disputes. And I think in a society that is increasingly preferring a secular approach to resolve disputes, this suggests a certain amount of incredulity that some people may want to live a religious life. So my first question for the panelists is, what are some of the benefits of using religious principles in family law, and how often do you see or hear of couples engaging in the use of religious principles to resolve their family law disputes?
Judaism has a legal tradition going back 3,500 years that supports and protects families. That system is flexible, sensitive, sophisticated, and evolving. And we have a proud history of success in how Jewish families achieve those goals, even though there are serious problems that we're going to address this evening. But overall, the picture is a picture of tremendous success, making use of that legal system. And making use of that legal system, that Jewish legal system, is a fundamental aspect of being Jewish.
In Islamic law, marriage is a civil contract. It's not exactly a sacrament as it is in Christianity. So it's a legal contract, and that's important to emphasize because there's no such thing as a prenup. The marriage contract itself is a prenup. But there are lots of similarities. For example, I was talking to Michael about the prenup in Jewish law, and it's very similar to Islamic law. I'll give an example. We all know that women have fewer rights of divorce in Islamic law than men. Divorce is unilateral, usually, but there is a possibility for women to include a condition in the marriage contract to to have the power of divorce. So you could, in theory, have a marriage contract in which the husband can unilaterally divorce his wife, but also the wife can unilaterally divorce her husband. And this is a little known fact in Islamic law that it's not practiced, but we will probably come to that point later. But it's something that can be promoted in the context of Muslims in Canada. So it is very useful, and it's obviously useful as part of human rights. It's an expression of religion that is, the state. I think the state should allow some expression of religious identity. There's also a debate in Islamic law about what the law is, and the diversity in Islamic law, which is mind-boggling.
Forgive me if you already know this, but in the Canadian context, when we're talking about all of the things that go along with a divorce, spousal support, child support, custody, access, those kinds of things, those are matters that generally fall to the provinces. And that's why in Quebec you can have a system where there's no arbitration permitted in the family law context, but in Ontario there would be. But when we're talking about divorce, divorce is a federal matter, and so we have a single Divorce Act in Canada, which covers all of the jurisdictions of Canada. So Section 21.1 of the Divorce Act contemplates judges assisting litigants where one party to a divorce refuses to remove religious barriers to remarriage. So typically where a man refuses to grant a religious divorce to his wife, what Section 21.1 of the Divorce Act does is it permits a court to dismiss any applications or to strike out any pleadings by that man until he removes this barrier to religious remarriage, or until he gives her the religious divorce.
21.1 was crafted with great care in order to comply with Canadian and provincial law, and in order to comply with Jewish law that forbids or invalidates a Jewish divorce that is coerced. One of the people instrumental in that is an attorney in Toronto. His name is John Sertash. And he tells the following story. He says that a couple of years after the law was initiated, he was somewhere, he says, a woman came up to him, and the woman was carrying a baby. And she said to him, "You see this baby? You're responsible for enabling me to have this baby. Because I was an agunah, a chained woman. And without 21.1, I would not have been able to remarry and have this child." And there are thousands of women across Canada today who would say the same thing. Rabbi Ox is a rabbi in Toronto, one of the foremost practitioners of Jewish family law in Toronto. He has written that 21.1 is responsible for what he estimates is at least an 85% reduction in get abuse. That is, get Jewish divorce, abuse, manipulation of one spouse over the other, 85% reduction, with no serious downside. But first shortcoming is, if a couple has no pleadings before the court, or if the recalcitrant spouse has nothing to lose, then 21.1 is not helpful. And the truth is, there is really no solution for that in a society like ours. But the second shortcoming is more serious because it's fixable. And that is, there is a tremendous inconsistency in the knowledge of and use by judges and lawyers of 21.1. If I would be granted a wish, my wish would be that all judges and all lawyers doing divorces would be trained in 21.1 to know how to use it correctly, to know how to use it aggressively but fairly in order to heal broken lives.
Muslim couples who marry religiously, even if they do so religiously and civilly in the Canadian context, typically agree to include a meher, or a bridal gift of monetary value that's to be paid by the husband to the wife upon marriage. So payment of the meher is generally deferred until or if the couple divorce. Several Muslim women have been successful in Canada in having the meher enforced by Canadian civil courts. In a case that originated in Quebec, a Jewish woman sued her former husband for damages for failing to give her the get, or this religious divorce that Michael was speaking of, as he had promised to do in a settlement agreement. So their relationship had ended, they had bargained for whatever it is they wanted. I'll get custody, okay, but then, I want the jewelry, okay, but then you have to promise to give me a get once the civil divorce is declared. And they signed all of this in a settlement agreement, which was also signed by a judge. The Supreme Court of Canada held in that case, and it's a case called Bruker and Marcovitz, that in deciding cases involving religion, you can't ignore religion. That this is a contract between a couple, and just because it had religious precepts in it does not mean that you could ignore the contract, particularly where what's being sought religiously is not contrary to public order, and making sure that you have the barriers to religious remarriage removed is seen as actually very complementary to the objectives of the Divorce Act. So, given those two sort of background pieces, my question is, should secular courts be used to achieve religious law objectives, from your points of view? And what are some of the advantages or disadvantages of pursuing such a strategy?
Canadian law and Quebec law recognizes that a religious ceremony can create a marriage that is legally binding, legally valid. Just as 21.1 recognizes that the state has an interest that divorcing spouses should be able to move on and remarry according to their religious standards if they wish. So, therefore, I would say yes, secular courts should be used to achieve religious law objectives as long as those objectives are compatible with public interest. Now, for Jews in Canada, there is one more step that would be tremendously helpful. In the United States, there's an organization called the RCA, Rabbinical Council of America. And a number of years ago, they developed a document that they call a Halachic prenuptial agreement, which is a prenuptial agreement meant to address a question of Jewish law. Halacha is Jewish law. And it specifically relates to the subject of divorce, and only to that subject. And the agreement says that the couple agrees before they marry that if, God forbid, the marriage should end in divorce, that the husband agrees to willingly give a get, a Jewish divorce, and the wife agrees to willingly accept a get. And the document adds the following proviso. If, for example, as is unfortunately most often the case, the husband is recalcitrant, then, since he is still married to this woman, and in Jewish law, a husband is obligated to support his wife financially, and they are no longer living together, but he still holds on to this marriage, he should be required to fulfill the obligations of the relationship that he insists on maintaining. And therefore, a financial amount per diem is required for him to pay as support because he is still married. And the document gives authority to secular courts to be able to impose and require that financial payment, thus being, indirectly, an incentive to give again.
That's brilliant.
In recent years, there has been wider and wider acceptance of this document. In cases where an RCA prenup was correctly done, there has not been a single case of an agunah, of a woman tragically chained to a marriage without being able to end. Just last December, a couple of months ago, this document was upheld in a case in Connecticut, Light v. Light, where the court held that the document was valid and imposed its financial amount. Now, a number of years ago, I wrote a version of a halachic prenuptial agreement for use in Canada that omits the support payment part of it, assuming, as I did, and as a number of people told me, that Canada would never, a Canadian court would never uphold the legality of such an agreement with a financial component. Consequently, of course, my document is a lot weaker than the RCA document. But it seems to me that in light of Bruker Marcovitz, in light of Light v. Light in Connecticut, we should be able to either use the RCA document as is or modify it so that it's acceptable for use.
In Hanbali law, a woman could put into the contract a condition that the husband cannot take a second wife, for example. In Hanbali law also, a wife could put a condition that the husband, that she has the power of divorce as much as the husband. So divorce could happen unilaterally by either side. It has been practiced, but not extensively. And it has been discussed mostly in the context of the Middle East, in the context of modernity and advancing women's rights. I would like to go to a case in Kansas in which there was a dower agreement, a contract, and because of the anti-Sharia legislation in Kansas, the court decided that they would not enforce the contract. The contract, it was an Iranian woman who was married to an abusive husband who was, I think, over 60 years old or something. And she was a younger Iranian woman who came from Iran. And after a lot of incidents of violence, domestic violence, she sued for divorce. And she got the divorce, but she wasn't able to get the dower, which was $250,000, because it is based on a Sharia principle and there's anti-Sharia legislation in Kansas. A similar case in New York, a couple, an American Muslim and an Egyptian Muslim, they had a similar dower agreement in which the court enforced the contract. They considered it as a valid contract because they have no anti-Sharia legislation.
There have been similar cases throughout Canada where a contract is signed and it's an Islamic marriage contract. But because marriage is also a civil act in the Canadian context, the Canadian courts just view it as a contract, and sometimes they view it as a marriage contract, otherwise known as a prenuptial agreement in the American context. And we had before Bruker and Marcovitz a lot of inconsistency in the law across the provinces. So in British Columbia, there were several cases of Muslim women at the end of a divorce, with a civil divorce, saying, the husband promised me $10,000 should our marriage dissolve. He should now give that to me. And most of the cases in British Columbia said yes, he should. It's a contract that's in writing. It's clear. It's not vague, and so they enforced the contract sometimes as just a general ordinary contract, and sometimes as a marriage contract. The distinction made between an ordinary contract and a marriage contract is that sometimes provincial legislation has heightened requirements for a marriage contract. So, you know, we can have, in ordinary contract law, something enforced, even if it's not in writing. If you have an oral agreement, that's enforceable as long as you can prove that this was an agreement. But for marriage contracts, they sometimes have heightened requirements. In the Ontario context, before Bruker and Marcovitz, we had a court, in a case called Kaddoura and Hammoud. Same situation, the husband agreed to pay, let's say, $20,000 should the marriage break down. The woman said, the marriage is broken down, I'd like to get my $20,000, please. And the court said, oh, no, 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 no. This is not something that we understand. This is some religious thing that you call the meher, and we don't do that in Canada. We don't enter the religious thicket, is what they said. And what he did, this judge, was he, I think very erroneously, compared this really clear contract of woman gets $20,000 at the end of a marriage with the Christian concepts of loving and cherishing your spouse, and said, you know, that those are moral commitments that really are committing the conscience, and compared, you know, $20,000 to that. And so she did not get the $20,000, the meher. But post Bruker and Marcovitz, what Madam Justice Abella said, writing for the court, was you can't ignore religion just because it's religion. If it's in the form of a contract and the couple agreed, and there's nothing contrary to public order, there's no reason why you can ignore it. Since then, in Ontario, we've had another meher case where the courts have said, we're going to follow Marcovitz and Bruker, and they granted the woman the meher of whatever amount of money it was. So I think there's been a real shift in terms of what we're seeing. I think what is the new sort of cutting edge thing that we have to sort of figure out is whether these contracts are just ordinary contracts or whether they should be seen as marriage contracts that have these heightened requirements. My view is they should be ordinary contracts. Usually when relationships dissolve, whether they're in a religious context or not, women are the ones who are left in poverty. All of the statistics show us that. All of the research shows us that it's women and children who end up in a more economically disadvantaged position. So my view is if the meher and the enforcement of the meher can provide yet another tool with which to combat that, then we ought to make it as easy as possible, and the ordinary contract law approach should be the approach that I think we should take.
Now, undoubtedly, all modern religious groups have elements that are flexible, have groups that are trying to be liberal, trying to adjust. Many, if not most, of the communities that tend to ask or want inclusion of religious law, tradition, tend to be somewhat conservative. Assuming that you had more inclusion of religious laws in more secular societies, what do you do when these rulings are not liberal? What protection exists for those cases and those victims, which are often but not always women, for example?
I think the answer is, thank God, among just about any group of Jews you will ever find, you will find different opinions. And practically, in Montreal, the insurance is the activism of many different people on different sides of the debate. And for any ruling that comes up or policy that is discussed, I may find it positive. I assure you, there's a group of people that will strenuously argue with me, and vice versa. And I would say that the defense of all sides comes through the open debate that takes place within the community. And that is a vibrant, another way to say it is cantankerous, debate that goes on every day.
I think that the public order argument that would be used by the judges. They would overrule any judgment that violates public order. So I'm not really concerned about the context, in the context of Canada. I'm not concerned about religious law going too far. I would make the opposite argument, and I do continuously make the opposite argument in the context of the Middle East, where there's too much religious law in the state. So the question here is one of rights, and it's a question of degree. I'm not really concerned about that. I'm more concerned about the Middle East, and that's why I would make the exact opposite argument I'm making tonight in the Middle East. Thank you.
Maybe I can complicate that a little bit further. Your question was very much a concern in the Ontario debate. A lot of feminist organizations that I was working for were very, very concerned about what happens to the most vulnerable people in this kind of a context. So what happens to the women? So let me, and I think those are really important concerns, and I think there have to be safeguards in place to make sure that you can't really agree. You don't want people to be able to agree to anything. So let me just give you a little bit of context, though. So arbitration, for those of you who don't know, I perhaps should have said this at the very beginning, is the couple has to agree. They have to agree to permit a third person to act as a judge would in deciding their family law dispute. That's what arbitration is. So at the first level, there's a lot of Muslims who said to me, not interested in family arbitration in the religious context. I think the courts would work just fine for me. Many, many Muslims felt that way in the Sharia debate in Ontario, and I think that's a valid response. Others said, why are you assuming that I cannot make this agreement for myself? I'm an educated woman, been born and brought up here, and I want to live my life religiously speaking. So why are we making the assumption that I'm somehow being duped and that I cannot consent? The other thing that people don't realize is that the way family law works in most jurisdictions in Canada is you can opt out. So the default regime is the regime that the statutes provide. And generally, that means when you're having a divorce, you split up the property 50-50, for example. But you don't have to do that if you don't want to. You can decide with your spouse in a domestic contract, in a separation agreement, in a prenuptial agreement, you can decide we're going to split the property 70-30, just because we feel like it, or because one person brought in more property. And we don't worry too much about whether that's fair. Courts have typically upheld those agreements that are not a 50-50 split. And they've done it as long as the process was fair, as long as the parties were entering into this agreement openly, voluntarily, with independent legal advice. The courts have said, that's fine. You're grown-ups. You should be able to do this. So I worry a little bit about over-policing religious couples where we're not doing this with other couples.
It is true there are cases where there's so much communal pressure that you can't argue for free choice. The person would become a social outcast if they don't follow the community's perception of what legal system should be followed. There will be people who will suffer from certain pressures. The state could be protecting those people by just banning religious arbitration or any religiously inspired contracts. But there are lots of people who are religious. We can't ignore those people either. So it's a difficult question. I don't have an answer for it.
Have there been any contact between Islamic and Jewish communities on these issues? I know there have been in the States on kosher and halal food, but has there been any contact and exchange of information in a regular way in Canada on family matters?
Let me tell you a little story, very briefly. First of all, I guess the answer is, here it is. Here it is. I have to tell you a story. So I was invited to participate in this program. I was very honored, and I didn't quite understand what we were going to do, so we had a meeting. Some of us in person, some of us virtually, but we had a meeting to discuss this program and what we were going to do. So my good friends over here were talking about these subjects, and I hear them talking about meher. They're talking about meher and money that's owed. And I'm thinking to myself, that's strange. They sound like Jews with a bad accent. Because of course the word is mohar. It's pronounced mohar. And it is a word that is in our standard ketubah marriage contract that dates back over 2,500 years, which is exactly that. The husband agrees to give his wife a lump sum payment of a significant amount of money, and that payment is held in abeyance until either the death of the husband, in which case the wife inherits it, or the divorce, in which case it becomes her support in one lump sum. So one of the really important things about this evening is the fact that we have so many points of contact, and it is so valuable for us to work together. And I'm very appreciative of you on the panel and of you for organizing this. And we need to do more of this, because one of the things you see is we have a whole lot to talk about. And we speak each other's language, even if you use a strange accent.
One of the main concerns in Ontario with religious arbitration was the autonomy of the woman. That the woman would essentially be a vulnerable party in this. And this was one of the main justifications in most of the literature was this focus. Why is it then that the idea of the state being able to sort of watch over, quote unquote, vulnerable religious women is so difficult was so difficult really for Ontario to take care of, let alone the rest of the country? So what is it that is so different about the vulnerable religious woman from the vulnerable party in other family matters?
So I think in Ontario what happened was Islamophobia, to be perfectly honest. I think what happened in Ontario was it was a group of Muslims who said we'd like to use Sharia law, and people went, whoa! I spoke to intelligent, educated people at that time, and there was, it seemed that the general understanding was when we're talking about Sharia, that necessarily means derogating from women's rights. And it doesn't. We know that there are multiple interpretations of Sharia, we know that there are feminist interpretations of Sharia, but that's what happened. That's what took over. And so even when Dalton McGuinty was announcing the result of this whole debate, he said there will be no Sharia arbitration in Ontario. He didn't say there will be no religious arbitration in Ontario, which is what he should have said. And actually, that's not even true. What the amendments say is that you can't have, if you want to do family arbitration in Ontario, you have to do it using the family law jurisdiction of one of the provinces of Ontario. But there's a lot that family law in Ontario, for example, doesn't have to like, if a couple says, if a couple is divorcing and let's say one of their concerns is custody issues and how this child ought to be raised, one couple may say, I want this child raised religiously and I want them to go to a religious school, and the other will say, no, I want them to go to this public school I went to. And believe me, couples fight about this stuff, right? They fight about really minute details. There's not a lot that Ontario's family law can offer, right? All that we offer is the best interests of the child, which is a very broad principle. But what does that mean? Right? And so when you've got a couple who is religious, it might be useful in that context to rely on religious principles where both of them are in agreement. So all that the amendments say in Ontario is that you can use arbitration as long as it's arbitration using a Canadian jurisdiction. And because the Canadian jurisdictions are so flexible, I don't think there is a prohibition on religious arbitration. But that's not what the media wants you to know. It's not what Dalton McGuinty wanted you to know. And that is precisely, in my view, because of Islamophobia. So we had Jewish groups in Ontario who were conducting religious arbitrations on a regular basis before this Muslim group announced this, and it wasn't considered a problem.